When approached by law enforcement, they first initiate the field interview. This is a time where they ask the youth for his or her name and any information they might have regarding the incident. The officer can issue the youth a civil citation or put the youth under arrest. Civil citation is a pre-arrest diversion program where the youth is not arrested, but instead law enforcement mandates the sanctions that the youth must complete. The civil citation program, derived from Florida Statute 985.301, was established in 1996 as a program that offers early intervention, counseling, education, and other appropriate community resources to divert first-time juvenile misdemeanor offenders from the juvenile justice system. Eligibility for the program is based on the current offense, prior delinquency history, residency of the youth, law enforcement officer discretion, and the willingness of the youth and the parent or guardian to participate. Clients complete community service hours assigned by the law enforcement officer at local approved community work sites. Clients may be ordered to complete other sanctions as well. If the youth fails to complete the assigned sanctions of the program, he is then arrested for this charge. The Constitution reserves many rights for those suspected of a crime. One of the fears of the framers was that the government could act however it wished by simply saying an individual was a suspected criminal. Many of the rights in the Constitution and the Bill of Rights, such as the right to remain silent and the right to an attorney, are designed to ensure that those accused of a crime are assured of those rights. This was the crux of the issue in Miranda v. Arizona. In 1963, Ernesto Miranda was accused of kidnapping and raping an 18-year-old mildly retarded woman. He was brought in for questioning and confessed to the crime. He was not told that he did not have to speak or he could have a lawyer present. At trial, Miranda's lawyer tried to get the confession thrown out, but the motion was denied. In 1966, the case came before the Supreme Court. The court ruled that the statements made to police could not be used as evidence, since Miranda had not been advised of his rights. Since then, before any pertinent questioning of a suspect is done, the police have been required to recite the Miranda warnings. The statement exists in several forms, but all have the same key elements: the right to remain silent and the right to an attorney. These are often referred to as the Miranda rights. When you have been read your rights, you are said to have been Mirandized. A notice to appear or an NTA is a written arrest. If the youth is given an NTA, he has been arrested but will not be taken into custody. The NTA will inform the youth of his first appearance court date. If the youth fails to show up for this date, he may be issued a pickup order and taken into custody. If the officer decides to take the youth into custody instead of issuing an NTA, the youth will be taken to the Juvenile Assessment Center, or JAC. The JAC is a comprehensive assessment center providing 24-hour screening and assessment of arrested youth. The JAC contains a secure booking and receiving area with interim detention and a shared data bank. In 1995, Leon County was in the midst of a crisis in juvenile crime. The city made national headlines after 3 local youths murdered a British tourist at a highway rest stop. Before JAC, Leon County's juvenile crime was the 3rd highest in the nation, only behind New York City and Miami, with no end in sight. Since the opening of JAC, juvenile arrests in Leon County and the Second Circuit have steadily decreased each year. If a youth is held in secure detention at the detention center, then the first visit to court will be a detention hearing. The judge will decide whether he may stay locked up in the detention center for a while or if the youth can go home awaiting the second visit to court, the arraignment. If the youth was not held secure at the detention center, then the first visit to court will be for their arraignment hearing. At both hearings, the judge will tell the youth what law he has been accused of breaking. The judge will also ask whether he wants a lawyer to help him. At the arraignment, the state attorney's office might offer a non-judicial diversion program, a plea, or the judge will ask the youth whether he wants a lawyer. If the youth or their family cannot afford a lawyer, the judge will appoint one to help. If the state attorney's office offers the youth a non-judicial program, this means that usually no petition has been filed in their case. This offers the youth a second chance with a virtually clean slate. If the youth successfully completes a non-judicial program, then the youth will not be prosecuted or convicted of a crime. Many times, people give up their right to a speedy trial and want to enter a plea instead. A plea is a proposed written agreement between the defense counsel and the state attorney. If the judge accepts the plea, then the judge will hand down the youth's disposition. The youth and his family does not have to accept the plea if they do not feel it is in their best interest. But if they do accept the plea, they have 30 days to appeal the decision. Under the Sixth Amendment, everyone has the right to a speedy trial, and to be confronted with the witnesses against him, and to have a necessary process for obtaining witnesses in his favor, and to have the assistance of a counsel for his defense. The state attorney's job is to prove that the youthful offender has broken the law. The defense attorney's job is to show that the state has not proven that. After the hearing, the judge will decide if the youth has broken the law. If the judge decides that he has not, then the case is over. If the judge decides the youth has broken the law, then he will decide what will happen next. If the youth is placed on probation, he continues to reside at home, but the judge will order the youth to comply with certain requirements, also called conditions or sanctions of probation. These include, but are not limited to, community service hours, an apology letter, a mandatory attendance at school, a curfew, and/or counseling. The Juvenile Probation Officer, or JPO, works with the Department of Juvenile Justice and will help the youth get these sanctions done. But it is also required to tell the court if the youth does not follow any of the probation conditions. Violations of probation can either be technical non-law violations, such as failure to comply with curfew or school attendance, or a new law violation when an additional arrest occurs. Juvenile residential and correctional programs, according to state law, are grouped into 4 custody classifications based on their population-assessed risk to public safety. These classifications are low-risk residential, moderate-risk residential, high-risk residential, and maximum-risk residential. Offenders classified for placement in the low-risk levels are those assessed as a low risk to public safety, yet require 24-hour supervision. Current offenders range from first and second-degree misdemeanors to third-degree felonies, no life or first-degree felonies, no sex offenses, and no juveniles whose delinquent acts involve firearms are eligible for this level of commitment. Juveniles at this level may have unsupervised access to the community once placed in a residential facility. Offenders classified for placement in this moderate risk level have been assessed as a moderate risk to public safety and require 24-hour supervision. These facilities are either environmentally secured, staff secured, or hardware secured. The majority of these offenders have committed serious property offenses, and their offending is characterized by frequent and repeated law violations. Juveniles at this level may have supervised access to the community once placed in a residential facility. Offenders classified for placement in this high-risk level have been assessed as high-risk to public safety and require close supervision in the structured setting that provides 24-hour secured custody, care, and supervision. These facilities are secured by hard wires such as locks, razor wire, and security screens. Placement in these programs is based on a concern for public safety. Juveniles at this level may not have access to the community. Offenders classified for placement in the maximum risk level have been assessed as a serious risk to public safety. These offenders require 24-hour custody, care, and supervision in a maximum hardware secured setting. All offenders in this facility live in a single cell. Offenders placed in this facility are chronic offenders that have committed violent offenses and other serious felonies. Youth at this level may not have access to the community. The state attorney's office has the discretion under state law to direct file on a juvenile 14 years old and